Hi, I'm Ian Hull, and welcome to 2 Minutes with Hull and Hull. On my podcast today, I want to cover issues that arise out of estates and family law scenarios and typical issues. I had the privilege of being a guest on the Ask Andrew show. Andrew Feldstein is a noted Ontario divorce lawyer and has a great show called Ask Andrew. I was his guest last week, and it gave rise to me thinking about some of these issues that relate between family law and estate law. Number one, priority always, whenever we're in a situation where we are in a marital breakdown, I always tell my clients to do a new will. Two things. One is marriage revokes a will, and that's the law in Ontario, and that's something that obviously is a dramatic change in your will planning circumstances should you get married. But secondly, I always want my clients to think very seriously when they're in a tough marital situation and separation has occurred as to whether or not they should do a will. And the answer is almost always yes, because most often in those situations, the client does not want the estate to flow to now is going to be a former spouse. And so I will often remind my clients, as soon as they're starting to go down that route, to consider whether they should do a will and to do it quickly. And sometimes I'll even urge them to do a holograph will just on the moment, although not something that I think is a great planning tool, but one that needs to be considered. So if you're in a situation where separation has occurred with your relationship, doing a new will is a number one priority. So thanks so much for joining me with 2 Minutes with Hull and Hull.